so I would ask the court to inquire from the state, if this is truly an ongoing investigation, when is it going to come to a head? Today, tomorrow, or in the middle of this trial?
YNW Melly. Remember him? He's charged with 2 counts of first-degree murder, accused of killing his 2 childhood friends. Now, he's already been in jail since 2019, and yes, he's already been on trial once, but we know how that ended.
You don't have to keep a juror inquiry form. It indicates that after further discussions, reviewing the evidence, and speaking freely amongst the jurors, you're still unable to reach a unanimous decision. So at this time, what I'm going to do is just declare mistrial because it's mistrial.
Now, that mistrial was declared back in 2023. Since then, there's been a slight change at the defense table, and there's been a prosecution shakeup too. And in a surprising move, the state wanted some more time before retrying the case. But does the new judge overseeing the case agree? Thanks for joining us on Law and Crime. I'm Elizabeth Millner. Now, it's been a while since I talked about YNW Melly, mainly because I was covering another high-profile case right here in New York. But over in South Florida, Melly remains where he's been, in lockup. Now, depending on the outcome of his retrial, he's facing anywhere between life in prison or the death penalty if he's convicted. Now, when does his retrial begin, you might be wondering? Well, in about 2 months, despite a push for a delay.
February of 2019. Mr. Demons voluntarily surrendered and was charged with 2 counts of first-degree murder, wherein the state indicated they were seeking the death penalty if, in fact, he was found guilty. In October of 23, Mr. Demons was rearrested for tampering with a witness, directing the activities of a criminal gang, solicitation to commit tampering, and conspiracy to commit tampering.
So that was a little snippet of the charges Melly faces, but I'm sure those following the case already knew that, and likely already know the allegations in the case too. Melly, his friend Cortland Henry, and their friends Christopher Thomas Jr. and Anthony Williams were all at the studio together, and all hopped into the car together after the late-night recording session. Christopher and Anthony never made it home that night, back in October of 2018. They were killed in a drive-by shooting. But prosecutors allege it wasn't random. It was someone from inside the car that made the fatal shots and staged it to look like a drive-by shooting. Prosecutors allege Melly pulled the trigger, and Cortland helped cover it up. And while I talk about how Melly's been in jail for more than 6 years, it's been nearly 7 years since Anthony Williams and Christopher Thomas Jr.'s families' lives were changed forever, with no closure on the case so far. So Melly's mistrial happened in late summer of 2023. Now we're approaching late summer of 2025, and Melly's trial is going back to square one. Well, kind of. His retrial is now moving forward in September of this year, despite objections from the state who wanted a delay in the trial.
I have the state's motion to reconsider or order moving forward with the trial on September the 10th. The trial date remains set on September the 10th. I did that last July 8th, 2024, although there's no motion to continue filed. I did read the motion. I guess I'll treat this as a motion to continue. I did read the authorities cited therein. I did read again, Florida Statute 924-071. Additional grounds for appeal by state, time for taking and the stay of cause. I likewise again reviewed the omnibus order on defendant's motion to suppress 1 through 13, which was entered by Judge Murphy on December the 20th, 2023. I also reviewed the order from Judge Murphy denying the defendant's motion to set aside stay, and order granting defendant's motion to modify the stay to allow discovery to proceed. That's entered May 2nd, 2024. I likewise reviewed a Florida Supreme Court case called Mitchell v. State, 911, 7-2nd, 1211. The Supreme Court case of September of 2005 regarding the serious constitutional issues that are implicated if the state were to be automatically entitled to stay the effect of the decision adverse to the state in a criminal proceeding. So, understanding that I've already looked at all of that, State, anything else that you would want to tell me in support of your motion?
No, Judge. My motion basically covers the previous court's orders, the statute, the case law in terms of how this case is stayed.
Okay. Defense. Do you all want the case to be stayed? The state says it's stayed, so do you agree with their motion?
Can we
not agree with it?
Can we have one moment?
Sure. Yes, sir.
Against our advice, our client wants to proceed.
So you don't, you object to their request for me to determine if it's automatic stay.
Based upon what our client has instructed us, yes, sir.
Okay, so let me make the record crystal clear on this one as well. I am aware that 924-071 calls for an automatic stay while the state is appealing some orders they want to appeal. In this particular case, Mr. Dennis happens to be charged not with the bail against that. So, state, let me ask you, and I'm going to ask you. Judge Murphy entered this motion to suppress, which is the subject of the appeal right now. He entered this order on December 20th, 2023. That was 568 days ago. And in that order, he says at the end, the court has not been moved to consider the suppression of specific evidence. It is up to the parties to inform the court as to what specific evidence falls within the suppression order and what specific evidence is admissible pursuant to that order. When we were here on the defendant's renewed motion for bond on May 6th, that was 65 days ago, I asked you all, had you gotten together and figured out what specific evidence falls within the suppression order? I'm going to guess that hasn't happened.
No, Judge, I made the proffer to the court last time as to what that evidence would be.
It was basically penalty-based evidence, for lack of a better term.
No, they were aggravators. They go to membership in a gang. They were things that the jury would have to find before going into penalty.
Not aggravators as to the death penalty,
Sorry.
aggravators as to the gang enhancement itself, Your Honor. That was charged. He was charged in committing the murder for the furtherance of a gang, which is an aggravator in terms of the guilt.
Something that they would have to find by way of an interrogatory.
Yes.
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 No, objection, that's not true.
That's not correct.
So you all don't agree on that?
No, we don't.
No, what you just said, we do not agree on. There is, I'm sorry.
Have you all done what Judge Murphy ordered you to do in 2023? It is up to the parties to inform the court as to what specific evidence falls within the suppression order and what specific evidence is admissible pursuant to this order. Have you all done that?
May I answer the question this way? At that time, the state appealed it all, which stayed everything. And so at this point, the law on whether or not Judge Murphy was right or not is all up at the fourth, and it stayed. We can't determine that in a stayed case. It stayed.
You can't talk to the state and decide what this applies to?
I just argued what I have to argue, Judge.
Well, I
You're
want-
saying
I
it stayed for only one
I want
purpose,
you to
but
answer
not.
my question.
The answer is we are stayed and unable to do so.
So you don't even know what evidence the order is.
No, I believe we do, and I think that's on appeal at the fourth. But during a stayed case, we cannot do those things. And that's why it hasn't been done. Not because we haven't wanted to. They appealed it. It stayed.
Unfortunately, to also remind the court, the defense did cross appeal, so even stuff that would remain in is also potentially can now be excluded should the fourth rule in the defendant's favor.
And that's still pending before the fourth.
But you don't agree with their request. You want to go forward. That's what you just told me. Your client wants to go forward.
That's what he said.
So according to the Sun-Sentinel, the original judge on this case, Judge John Murphy, ruled prosecutors wouldn't be able to reuse some of the technological evidence the state presented to help establish Melly's alleged motives, gang affiliation, and consciousness of guilt. The appeals court has yet to rule on if those restrictions will still stand and are supposed to hear arguments about it on September 16th, a week after Melly's retrial is supposed to begin. But as you just heard from the judge, the case is still set to move forward on September 10th, and the issues in front of the appeals court aren't enough to delay the trial. But the state isn't the only one suffering some issues, too. The defense is, too. They accuse the Broward State Attorney's Office of prosecutorial misconduct, and Melly faces another charge of witness tampering. Oh, and one of his lawyers is under investigation. But as of this recording, she doesn't face any charges.
I don't know how we can properly defend Mr. Demons on the evidence of tampering with a witness, solicitation, conspiracy to tamper, when we don't know all the facts. would ask the court to inquire from the state, if this is truly an ongoing investigation, when is it going to come to a head? Today, tomorrow, or in the middle of this trial? And how come you have not pursued, when you file a memorandum of law, saying that Ms. Liberty must, regardless of what Mr. Demons wants, regardless of what the defense team wants, must get off this case? I don't know how they can do this.
So Melly's trial is moving forward in September, nearly 7 years after Anthony Williams and Christopher Thomas Jr. were murdered. How will his retrial differ from his first trial? Well, I guess we'll have to wait and see what happens. But let's break it down with criminal defense attorney Safa Robinson Ferrer. Safa, first of all, great to see you. Like, I haven't seen you in a while in this format, I should say. But
to see you, Queen Elizabeth.
Yeah, oh, thank you. But I'm curious, like, on your thoughts on this case, as opposed to what we were normally talking about, which was Diddy. But in this case with YNW Melly, are you surprised that the judge said, let's move forward with the case, even though the state was waiting for whatever the appeal court was going to say about restrictions, like technological evidence, gang affiliation, all of that stuff? But are you surprised the case is moving forward in September?
I'm not surprised at all. Mr. Dimmons has been waiting in custody to see a trial on this case since, I believe, 2019. You know, he obviously went to trial before that ended in a mistrial, and he's remained in custody since that. And he has a right to a speedy trial, a constitutional right to a speedy trial. And I think in this particular case, the judge is trying to ensure that. So it's not surprising here that the judge is saying, no, we're going to trial on this particular date, and everybody needs to be prepared to move forward.
And I thought it was interesting, too, because just watching back the hearing, it was actually Jamel Dimmons, a.k.a. YNW Melly's, decision to move forward with this against the advice of his attorneys, his defense attorneys. What do you make of him kind of pushing himself to kind of get this trial going just to see what's going to end up happening?
Yeah, you know, I think at the end of the day, he's been sitting there for quite some time, and he just wants to move forward with his life, whether that is an acquittal so that he can get back to the public and get back to his work, or accept his fate as a convicted felon, someone that has been convicted of 2 counts of murder. So a lot of times with clients, and particularly defendants, they don't like to sit in limbo. And considering, again, he's been in custody since 2019, so we're talking years. We're not just talking a year. And we saw how quick Mr. Combs' trial went to trial, or Mr. Combs' case went to trial. Mr. Melly, or YNW Melly, has that same exact right. And so it's not surprising to me that he wants to just get it over with, you know, and he probably expects or thinks that he's going to have something favorable to him as he commences on this trial, considering that the other trial landed in a mistrial, which essentially for that moment was a win for the defense.
And I think he was even hoping that there would be a possibility he could be out on bond or bail, and then obviously that didn't happen. He's remained in custody since, so I can understand why he wants this to move forward, just to see what's going to end up happening. And given that this is a retrial, who do you think has kind of a tougher hurdle to overcome? Is it the prosecution? Is it the defense? Especially knowing that the offense that had happened, that being the double murders of YNW Juvie and YNW Sack Chaser, Anthony Williams and Christopher Thomas Jr., happened back in 2018. Who do you think has the tougher hurdle for this retrial?
I think that the tougher hurdle is always going to be remain with the prosecution, because it's their obligation to prove his guilt beyond a reasonable doubt. They have to prove each and every element of each and every homicide offense beyond a reasonable doubt that he intentionally murdered these individuals. And that's always a hurdle. That's always a burden that the prosecution has to get over. At the same time, there are things that the defense is really going to have to work on here. This case landed in a mistrial previously, so the likelihood is that, again, if they came back hung, that some believed that he was guilty and some believed that he was not guilty. And so the defense is going to really have to hit away at the prosecution's arguments and theories that Mr. YNW Melly committed this murder. And so I think that both of them have a job to do, and it's going to be a pretty tough job on both sides. I think the prosecution's hurdle is a little bit higher than the defense.
Because, again, they have to prove the case beyond a reasonable doubt. And is there possible doubt that may linger? It'll be, I guess, up to a jury to decide eventually when that happens. But there are a lot of high stakes in this case, too. Not only is this first-degree murder and 2 counts of first-degree murder at that, but it also could be a death penalty case if Melly is convicted. What do you make of just the high stakes, especially that he is facing the death penalty?
Very, very, very high stakes in this case, and he's got everything to lose. He's got his life to lose. So this isn't just a case here where he's going to be spending the rest of his life in prison. This is a case where he could be set to death because of this conviction or because of these convictions. So with respect to the defense team, they're really going to have to do a very fine tooth comb job with cross-examination, making sure they cross their T's and dot their I's, and essentially save his life on the back end. If he is convicted, then they will enter the penalty phase, and his attorneys will argue, for him to remain in prison for life. The prosecution more than likely will ask for the death penalty based on the deaths, and the judge in Florida, I'm not sure if it's the judge or the jury that makes that determination, but ultimately the stakes are significantly high because he does face the death penalty.
Yeah, and it's interesting too, because I remember when this case first happened back in 2023, or I should say the first trial happened in 2023, and I was always curious, especially about the death penalty aspect, given that law came down. It doesn't have to be unanimous. It just has to be kind of a majority thing. And in terms of that, what do you make of that? The jurors don't have to be unanimous on deciding the death penalty. It really just has to be kind of a majority, either go for it or they go against it. But what do you make of just that added layer to it?
Yeah, that's a pretty difficult layer. And, I'm of the opinion, of course, as a defense attorney, that, they have to have a unanimous guilty verdict. I think that they should make a unanimous decision on whether or not to put that individual to death, or for that to be that decision to be in the hands of the judge who may be more equipped to handle or to make a decision like that, as opposed to lay people from the public who may not fully understand the law, may not understand certain things with respect to the death penalty. So I'm of the opinion that they should all unanimously make that decision. The fact that it is, based on a majority, of course, that's what Florida determined to be, their standard. And so, unfortunately, if he's convicted, then they will have to deal with that.
Yeah, and it, obviously we're months away from, that possibility, because it could go in the completely opposite direction. We just never know with cases like this, because I even remember back during the first trial, it was like Melly, was kind of adamant that he was inside the car. He even made that kind of video at the end. It said Melly and his friends were victims of being a drive-by. Then he kind of did an about face. His friend came on the stand and was just kind of like, oh no, Melly was actually here. He wasn't in the car when this happened. None of that. But do you think that we could get these kind of like bombshell shocker moments in the retrial, or do you think it'll be more or less possibly the same as the first trial?
I think it's going to be pretty similar to the first trial, and I know that there were some bombshells that were dropped in that first trial, and the defense particularly is not going to want to shy too far away from whatever the testimony was, or whatever the testimony that was provided to them in favor of them during that first trial. So, whoever's going to testify on behalf of the defense, if they testified during the first trial, they don't want to get back on the stand during this trial and say something totally different and totally opposite. It's going to destroy the credibility of the defense's theory in their case. So they got to be really careful with that. And same for the prosecution, depending on who they call as a witness. There was clearly some sort of doubt that was laid out during that first trial. And I think that the defense should continue to pick away at that and go at that, because the prosecution didn't have a clear-cut case then. They don't have a clear-cut case now, which is why this case is going to trial again.
And also, really quick, Safa, I just want to clear up something I had mentioned earlier, just about it being a majority rule. It really just has to be 8 people in 8 juror majority in order for the death penalty. So still a majority, but it has to be at least 8 people, which still is pretty scary to think about if you're a defendant in a case like this. But also, with us being kind of months away from this trial, or really 2 months at this point, how important do you think jury selection will be in a case like this? Obviously, from other high profile cases that we've covered, it's very important, this voir dire process. But in a case like this, where the stakes are high, including even death penalty as a possibility, how important do you think jury selection will be?
The case is won or lost during jury selection, and we say that all the time in the legal profession. In this particular case here, the defense is going to want jurors specifically that are quite religious. And so, as we're preparing for voir dire and jury selection, we're thinking about the ideal juror that we would want. Even as a former prosecutor, the prosecution's ideal jurors, the defense's ideal jurors. In this particular case, with respect to people who are heavily involved in religion, oftentimes they come off as great jurors for the defense because they don't like to hold other people in judgment. They believe that that is the responsibility of God or a higher being. And so, not wanting to hold someone in judgment, they don't like to usually find individuals guilty. Not only that, but if you're talking about the death penalty, they don't want to take a life. They don't think that that is their responsibility or their decision to make. Also, you want people, from the defense aspect who can relate to YNW Melly, who may be fans, who may, believe in him, believe in his case, young black men, young black individuals that may relate to him to some extent. And from the prosecution, you're going to want individuals who, are very law and order, very law enforcement, very geared towards, believing the police, believing in law enforcement. A lot of people who love true crimes, they're oftentimes, more favorable jurors to the prosecution as well. So each side has their different pickings of who they're going to want. They're going to try to knock off each and every person that the other side wants until they get that happy medium jury.
And it's interesting you say that, because I was thinking maybe the defense would want to go for the younger jurors too, but you saying the religious jurors, that kind of makes a lot of sense.
Yeah, I've had a ton of cases where I'm voir diring and I've had someone raise their hand and say, I'm Catholic, I can't hold someone in judgment. I can't find somebody guilty. That's not my job. And so it actually happens quite frequently.
Yeah. And I want to also go back to a point that you had made earlier, just about how important the cross-examinations will be in a case like this. Obviously, seeing the Diddy trial right in person, I saw how cross-examinations can really do wonders for the defense. And in terms of just the cross-examination versus the defense putting up some witnesses, do you think it's a good or a bad idea in a case like this to put up a ton of witnesses on the defense's behalf? Or do you think that they'll keep their list relatively small, maybe 2 people, 3 people, maybe even as low as 1 person? Do you think they'll go for a long list of witnesses on the defense's side, or do you think they'll go for kind of a shorter list?
I think they're going to go relatively small. And I don't think that they need to go, all the way with, a list of 26 witnesses. When it comes to essentially fighting these cases, the first thing that any defense attorney is going to look at is whether or not the prosecution has met its burden of proof beyond a reasonable doubt. And that legal defense that they haven't met their burden, they cannot meet their burden. We're not required to say anything, do anything, present any evidence, present any witnesses. And if you find that they have not met any element of this charge, you must find my client not guilty. And I think that's going to be the cleanest way for the defense to go in and really tackle or fight tooth and nail with the prosecution on these charges. Also getting to the credibility of certain witnesses and also challenging some of the scientific evidence that we can expect to see in this case when it comes to ballistics and all of those sorts of things. And that's going to be really crucial for the defense to tackle as well, because the prosecution is arguing that these shootings occurred inside of the vehicle. The defense is saying, no, they did not. So we're going to be looking at blood spatter. We're going to be questioning technicians and, ballistics reports and all of those sorts of things. And again, if the prosecution fails, if they can't present certain pieces of evidence, and simply just can't meet their burden, then they have to come back not guilty, regardless of whether or not the defense calls any witnesses.
And obviously, prosecutors don't have to prove a motive when they're trying a case, but do you think jurors really want to hear the why? Why did this happen? Why would somebody allegedly shoot 2 of their very close friends, 2 of their childhood friends? Do you think that matters a lot to the jury? It's, because me just watching cases all the time, obviously from working at Law&Crime, I'm always curious about the why, but do you think, in a court of law, the why really matters?
It does matter, because jurors are going to want to reason why they make the decision that they make. I have to have a reason why I'm going to find this person guilty. Did these murders allegedly take place because, It was a business deal gone wrong. Like, what is the person's motivation? And again, no, you do not have to prove motive, but jurors really like to get a full picture and a full grasp of, well, why would this person do this? Especially if these are two of his childhood best friends. What motivation would that be? And that's going to go to the defense's theory that he didn't do it. Why would he do it? These are his childhood best friends. They're in a rap group together. They've likely made money and or will make money together. So what is the motivation? And so it's going to be interesting how the jurors receive that. But although prosecution doesn't have to prove motive, the jurors like to have a really solid sense of reasoning as to why they're going to make the decision of finding a person guilty if they make that decision.
Well, Safa Robinson-Ferrer, obviously we're going to be following this case very closely, but I want to thank you so much for your time and your insight into this. But before we sign you off, we talk about YNW Melly, aka Jamel Dimmons, very often. But, I always think back to like Anthony Williams and Christopher Thomas Jr.'s family in terms of just how long they've gone now without justice as to what happened to their kids, their loved ones, their family. What are your thoughts on just how long they've been waiting for justice in this case?
Yeah, I think that it's important. And, this is a homicide case. This is a high stakes case. You want to ensure that there is integrity in the prosecution of this case because this family does deserve justice. And there isn't a person that deserves to be wrongfully convicted or in prison for something that they didn't do. So it's really important on both ends to ensure that this prosecution is done with integrity, that there is a significant amount of proof beyond a reasonable doubt. That way, if there's a conviction that comes from it, then fine. That will give the family the justice they need. And I'm sure that they want to get this over with because, they've been sitting in limbo as well, just as much as YNW Melly has.
It's been so long since 2018, October of 2018, so I can only imagine. And I, again, only can imagine how they're feeling right now. Safa Robinson-Ferrer, again, thank you so much for your time and your insight into this case. I really appreciate it.
Thanks for having me.
Melly will likely have another pretrial hearing before his September retrial, and Law&Crime plans to live stream his retrial on our YouTube page, so you'll never miss a gavel-to-gavel moment. And again, that retrial is slated to begin on September 10th. Thanks for watching us here on Law&Crime. I'm Elizabeth Millner.